Good evening, everyone. Welcome to our talk tonight. The talk is hosted by EasyView. Together is the joint event with MWTA and also Pistio Advisory. Let me have a brief introduction to you. What is MWTA? MWTA stands for Malaysia Will and Trust Association, formed in 2021. So it's a non-profit organization. The purpose of forming the organization is to raise the public awareness on will and trust writing, and also importance of succession planning. Across their activity, they do seminars and classes to promote the activity and also to train more industry advisors to raise the industry standard. Okay, whereby Pistio, what are Pistio? Pistio Advisory is a wording from Greece representing the meaning of trust. They formed in 2016, is Malaysia's largest trust advisor team. Up to date, there are close to 3,000 advisors nationwide. So in 2020, which means last year, they have achieved to set up 7.3 billion across the nation with more than 10,000 customers. So Pistio does online seminar and training to let the client understand the benefit of trust and complete the trust planning together with UBB Apana. All right, so our topic tonight will be telling you the 5 important points you need to know when you draft your will. So the content will be what is will writing, what happen if someone died intestate, a complication, and why, and importantly, why Malaysians do not have the awareness to draft the will. So we have our speaker tonight, a lawyer How. He's graduated from Northumbria University, Newcastle, admitted to as an advocate and solid in the High Court of Malaya 2011. So previously working experience with general insurance company, trustee company before admission to during the practicing and admission become a lawyer. Okay, also he is specializing in conveyancing case, litigation matter, and also estate planning matter. At the same time, Lawyer How is also our legal representative, legal advisor of EasyView. Without further ado, I pass the mic to Lawyer How to kickstart our session tonight. Thank you, Lawyer How.
Thank you, Junwei. Thank you. Welcome, everyone. So welcome. Thanks for you joining the sharings tonight. And so I believe that many of you who joined tonight want to know what is the will drafting about. Okay, I believe many of you want to draft a will, but they have no idea how to draft a will, where to start, and actually what is the purpose of having a will. So I hope that after these sessions, you will be able to have a brief idea what's the will and what's the purpose, and if you want to write a will, how to start, and at least you have a brief idea what to do. So what's a will actually? A will is a legal document, okay? So that when you pass on or you pass away in future, you are able to let your family member to know what you have during your lifetimes and how are you going to distribute your estate to the beneficiaries, what is your arrangement, etc. So after tonight's sessions, I hope that you're able to capture and or able to have an idea what is the will about. So many of you might wonder what happened when the people pass away, what happened to the estate. So some of you might mistakenly thought that the will, the estate will be automatically transferred to the beneficiary, which is totally wrong. So there's no such thing, because the authority, land office, they wouldn't be able to know when you pass away, whether it's still alive or whether you died, until someone inform them, ask them to do something. So what happened when you pass away? The answer is very simple. All your assets will be frozen. So what asset will be frozen? That will be including your fixed deposit, your bank's accounts, your CDS account, if you buy shares, your house, your car, your oil palm tree, oil palms, or your unit trust, or your factories. So all these, all the assets under your personal name will be frozen, except 3 assets, which is EPF, insurance policy, or trust that you have set up with a trustee company. So all these 3 will be able to frozen. So what happened? How are you going to defrost it, your family member? What if a family member wants to get the money from your estate? So how to do it? How to defrost it? Come, let me show you this is the simple chart that I can show you. So if someone die testate, normally what we call it die with will. In legal term, we call it die testate. So the family members will approach the law solicitors. Normally, that will be the executor. Executor will approach the solicitor like us to prepare a cause paper, then to apply for a grant of probate in High Court. So once the grant of probate has been extracted, so the executor will carry on his duty to distribute the asset according to will. So we'll come to that later part. So what happens if someone died intestate? So some people, they might mistakenly thought that the government will confiscate the asset, which is totally not true. So if someone died intestate, means without will. So the family member going to have a family meetings, who to appoint as the administrator, who want to manage the estate. So once they have once all the family members, they can nominate 2 persons, 1 or 2 to be the administrator. Next, another challenge is how are they going? They have to list down the asset and the liabilities of the deceased persons. So normally this part is the most challenging part because sometimes most of the time the parents or the siblings, they don't inform or they don't tell the family members what do they have during their lifetime. So the family members got to find all the documents available to them to restructure it. Is doing a puzzle piece by piece, and then get all the information from the correspondence. So to list down all the asset and the liabilities. So after that, then only we decide if the total asset is 2 million and above. So the solicitors, we are going to file the matter in High Court to apply for what we call grant of letter of administration, grant of LA in short form. So if the estate is below 2 billion, so we are going to file the application in Land Office. So also the same, we are going to get the grant of LA. But Land Office is the most challenging part. Why? Because it takes a very long time for us to get the hearing date. So today we found we can only get the hearing date after 9 months to a year. Why? Because the Land Office, they will have to send to a valuation department to value the asset of the property, how much is the market value, because they have to determine how much to charge for there's also some administration charge if you file the application in the Land Office. So it will take a very, very long time. Normally, if someone dies testate with will, we can resolve the matter within 3 to 6 months. If the list is completed, I mean the list of asset, everything, the will is properly drafted. But if someone died intestate, if the list of asset is okay, then normally we can resolve it within 1 to 2 years. But if the list of asset is not complete, or the deceased person is not a well-organized person, then it will take at least 2 to 3 years to complete and dissolve the estate, meaning to say to get the grant of LA and distribute the estate to the beneficiary accordingly. Worse, if you have the person, majority fall under this category, 2 million and below. So at least you have to take few years to dissolve this. So if the estate is 600K and below and it's only for movable asset, then normally we can recommend you to go to Amanah Raya. Of course, Amanah Raya also, they can resolve all these LA issue, but they have trustee charges. So they have their own schedule charge. So if someone die testate, so the property will distribute according to the will. But what happens if someone die intestate, means without will? So how are they going to distribute the asset? So basically, technically in Malaysia, we have what we call Distribution Act. So whether you like it or not, it's already fixed. So this is how the Distribution Act distribute the estate if someone die intestate. So from the chart, actually you can see if someone die, he or she is not married, there's no spouse, no issues. Issues means children. So 100% will go to the parents. But if someone died, only left behind the spouse and the parents, so they'll share the estate equally. So parents, if both survive, then means both will share the 50% equally. So if someone left behind parents, spouse, and issues, so 1/4 will go to the parents, 1/4 will go to the spouse, and half will go to the issues the children. So if someone died, there's no parents, only spouse left behind, spouse and issues. So 1/3 will go to the spouse and 2/3 will go to the issue equal. So let's say you have 3 children, so 2/3 will divide by 3. That's how it works. So if you have someone dies without parents or spouse, then only left behind issues, then 100% will go to the issues, the children. So if someone died, there's no children and there's no issues, only spouse, then 100% will go to spouse. But what happens if someone died, but there's no spouse, no parent, no issues? So you will distribute to the siblings in equal portions. So there are one scenario whereby, the Chinese, before they die, the last word, the parents purposely inform one of the child and mentioned that not to distribute the portion of the estate to one of particular siblings. But after that, she died. So the family member came to us and asked us whether can we not to distribute the portion to this particular beneficiary who is the siblings. We say no, unless they die with you. So if the deceased person died without will, strictly we have to follow this distribution act, regardless you like it or not. So they asked me further, what if I purposely declare this particular beneficiary from the list of beneficiary? So the risk is that administrator who managed the estate will get sued by this beneficiary if he or she came to know that she's entitled to a share. So who wants to take the risk? So normally no one wants to take the risk, but for, right? So this is how it works in Malaysia. So if someone died in that state, so what is the consequence? So normally they might have some family dispute. So when it comes to appointment of administrator, why we say so? Because some of the siblings, they may not be able to see eye to eye. So if the parents or the father is a very rich family man, so the children might fight to be the administrator. So it will cause a family dispute. So second, you are not be able to give or distribute your estate to the beneficiary at your own preference. So whether you like it or not, so you got to distribute the estate according to the Distribution Act, which is the chart that I showed you just now. So this will cause the complicated of the legal procedure, and it will cause delay, and it will make the next what we call the family members more difficult to manage the estate. So it will incur unnecessary expenses and increase the burden of the family member. So this is the consequence if someone died in the estate without a will. So normally it's a good thing when the parents leave behind few properties for the children. But if the parents, they never do a proper planning to his wealth or his asset during the lifetime, it will cause a nightmare to the family, because siblings might be fight each other purely for the money. Yeah. So to solve these problems, actually with a will, you can all solve this problem very simple way. So so next we are going to move to conditions. So some of you, you won't be able, you don't know what's the condition. Actually, to make a will, the condition to make a will is very simple. So long as you are 18 years old, if you are from West Malaysia or Sarawak, or 21 years old for Sabahan, you are sound mind, and make sure your will is written form. So either handwriting, typing, or print out. But in this modern world times, normally we use type wrapping. So, and not to forget, you must sign and put a time print at the last page of your will. So some of you might think that I must own a few properties, or I must be filthy rich to make a will. The answer is no. You can even make a will even you have one particular bank account. So you just imagine if one day you are not around, so how are you going to deal with the money in the bank account? You want to give it to your parents, you want to give it to your siblings, or you want to donate to charity. So just make a will, a simple will will do. Okay, once you satisfy all these conditions to make a will, so next, what are the things that you need to look for when you want to draft? So this is the very important. So many of you, you might not have idea what to do. So first thing first, you must, before you write a will, you must think who you want to appoint to be an executor. So executor is someone's, the responsibility is to manage the estate when you are not around. So this is the main functions of the executor. So I'll come to you in details later, but so second is please list down all your asset. And third one is please, how are you going to distribute the asset? You want to give your property A to your eldest children, you want to give the property B to your second child, up to you. There's no specific formulas to how to distribute your asset. So every person, they have a different thought. So there's no right or wrong. The only thing is you know best what is best for your children. So if you have minor, not to forget, please appoint one guardian for your minor. So if you are not around, so who you want to take care of the children. So minor is a children who below 18 years old, we call it minor. So last, not to forget, when you sign at the last page of the will, please get at least 2 persons to be a witness. So to witness your signature. Okay, so once you are aware of all these things, so now we are going to go into details how to do. Okay, first thing first, we will talk about the executors, obligations of the executor. So when a person pass away, actually the estate won't be transferred to the beneficiary automatically. You need a person to go and do all this work. So the person, we call it executor. So his responsibility including list down all the deceased estate. You got to prepare the asset and liabilities. So after that, once you got all this sorted out, then you approach the solicitors like us to go and apply for grant probate in court. So what we are going to do is we are going to draft all the court paper for him to sign. So he got to attend court once. So to for the court to extract the grant probate. So after he got the grant probate extracted, next he's going to pay all the deceased personal debts, including income tax. Ladies and gentlemen, many of you might think that once a person passes away, you don't have to pay tax or don't have to pay your debts. Sorry, you still have to pay it. So your next of kin have to pay it if you don't pay it during your lifetime. So last, if you have, after you have cleared all these things, your debts, so whatever remaining will be distributed to the beneficiary according to the will. Okay, this is obligation. So executor is someone who is very important to manage. He's the key person to run the show. If you, that's why he's power. He has a very big powers. Like examples, he can go to the banks to withdraw all the deceased monies, and by right, he's supposed to set up a trust account, estate accounts. So if you someone that who is not trustworthy, your whole estate will turn into a very big trouble. So your beneficiary might not be able to get what they want or what you want to give them. So normally we are advised when you nominate an executor, please appoint someone who is trustworthy, fair, and very responsible. So every person, you know your people surrounding you best. So okay, normally we don't recommend a person who is bankrupt, a person who is below 18 years old, or a person who is too old. Why too old? Some people, they might want to appoint their parents as a executor, but we don't recommend that because the parent is so old, 80 years old, the parents might pass away before him. So at that particular times, you got to redo your wills. So normally we advise a person to nominate the beneficiary as executor also if the beneficiary is above 18. Why? Because the beneficiary, he knows that eventually, this executor, he knows that eventually he's going to get something from the estate after he do all this work. So he'll be motivated to do all the work. Otherwise, if you appoint someone to a third party to be the executor to do all the work, but he's not benefit anything when he incur all his time and effort to do all these things, mostly people, they are not so keen, they are not so motivated. That's why they tend to delay all the things. Eventually, the beneficiary is going to suffer. Okay, so after this, once you are cleared with the executor part, then we are going to move the asset. So, okay, that asset will be including your bank's account, your saving account, or your FD account. I think majority of people here, we have it. So your car, how many cars you have? Some people, they have my own 3, 4, 7, 5, 6, 7 cars. So just list it down, all the cars in your wills. You might own properties, your condominiums, your bungalows, please you may list it down. Or some people, they might have shares in the company. You can actually list it down, provided your shares, you don't have shareholders agreements with your partners to mention that once you pass away, you're going to sell it back the shares to your partner. Because if there's such thing is mentioned in the shareholder agreements, please don't list it down in the will. Otherwise, you have a chaos when you are not around one day. So next will be jewelries. Please list it down specific. If you want to give a jewelry, let's say you have a specific like Rolex watch or Patek Philippe watch you want to give to your children. So please list it down, or please be specific when you list it down your asset in your will. Or some people, they like to do investment. They have a CDS account. You can actually view it in your will. So during will drafting, we have been receiving questions from clients. Clients sometimes they want to save the troubles. So they ask us, is it okay if I put all my movable and immovable asset equally to my children? So they like to put all these things. So the reason why is first thing first, they're lazy to go and dig out all this information. The second thing is they're lazy to go and think how to do. But they forget when they mention all, what does it mean by all? He might know, of course, the testator will know what he has, but the parent, but the children or the spouse might not know what he has. So examples, all my bank's accounts. What do you mean by all? So the spouse might not even know how many banks he has. Myself, I also don't know how many banks accounts my wife have. So needless to say, my children. So I don't even know how many bank accounts my parents have. So please don't use the word all. So please be specific, so that the purpose of will writing is so that your next of kin, they will be able to know what you have during your lifetime. So try to avoid all these words or no, it's going to create a very confusing later part. So next, okay, will be some of you might be driving your car, but bear in mind, if you are driving a company car, so technically speaking, if the car that you are driving is not belong to you, if the car is registered under a company name, it's company asset. So please don't write in your will because whatever registered under the company, your car, shop lot, factories, please, if it's registered under a company, it's company's asset, not your personal asset. Will is only cater for your personal asset, please. So company and shareholders is separate entity. So some people, they might come and tell us, hey, I'm the majority shareholder, I'm the 99% shareholder of the company. So the company technically belongs to me. So why can't I just write my car in the company? Sorry. Technically speaking, even though you are the majority shareholders, whatever assets is belong to a company is still a company. So when you pass on, you're not around, basically you're supposed to return the car to the company. So it's company asset. But what you can do is you can always view your company shares in, you can write your company shares in the will. So who you want to give the company shares. Okay, so some of you might have questioned that what if insurance and EPF? So normally for insurance EPF, you don't need to write in the wills. So because you have nominations. So for those of you, if you have not done any nomination for your insurance or your EPF, please go and do it. Okay. So normally we will ask you to prepare if you want to do a will, the IC of the testator, executor, and also the beneficiary. If you have properties, please prepare a copy of the title or assessment or quick rent. Or if you have you want to view a motor vehicle, please prepare a registration card. Or if you have bank accounts, please you have bank account books or statement. Of course, we don't need to know how much you have because we know all money's in and out. But we need to know the bank's account number and which branch. Normally, we just write it down in the will. So for company shares, if you have any company shares, please give us the company forms. So is it compulsory? Some people ask. Actually, it's not compulsory. We leave it to the clients to make the decision. So why we need that? Because at least we have a documents to double check. So some clients, they are very secretive. They say, I cannot let you see all these things. Okay, fair. But you got to make sure what you type is correct. Because we are going to follow the information as per what you type. But if you type something is wrong, let's say a beneficiary's name's wrong or IC number is wrong, so we are going to, when we prepare the will, everything will be wrong. So we're going to have problem later when we come to execution part. So that's the intention now. That which is why we will request a copy of documents. At least we are able to double check the information to make sure that it's correct when we prepare a will. Okay, once we sort out the documents, next you're going to think who you want to give the asset. So some of you might mistakenly thought, hey, I only can give the asset to my children or someone related to me. The answer is no. You can build anything. You can build to anyone you want, even though there's not blood related relative. That also doesn't matter. You can build to a friend. Up to you. It's your money. Who you want to give is entirely up to you. But if you have minors, so normally we recommend you to set up trust for your minors. Traditionally, Chinese, for some reason, Chinese, they like to ask the brothers or the siblings to take care of the children, and then they give the money part under the siblings. So if the siblings, those who are in business, they're doing well, doesn't matter. For those who are not doing well, so they might borrow. We use the word borrow from the from the minor for the niece or nephew. So by the time when eventually when the needs go out, they might not be able to get anything because the uncle or the auntie might finish up all the monies which is left over by the parents. So which is why to avoid all these things, of course, we are not saying that all uncles will do this to their nephew. No such thing. But it happens. So to avoid all these things, normally we advise you all to sell a trust, take care of your children's welfare. Okay. So we are done with beneficiary. Next, what is guardians? So normally, if you have minors, we will recommend you to write the guardians in the will. So the guardians is a person to take care of your child who is under 18 years old, who is a minor. So normally we recommend someone who is quite close to your children, so like the grandparents or uncles or the auntie, to be the guardians of the children. So at least someone that's trustworthy and responsible person. That's very important, because if you appoint someone who is not responsible or tend to neglect your children, then eventually just pity your children. No one is going to take care of him or her. Yeah. Okay. So you understand your guardian. Now we come to, this is quite important part also, witness. So I have seen some of my clients, they come to us, they try to write themselves a will, but without witnesses. So if a will without witnesses is not valid under the law, so it must have at least 2 witnesses. So whenever you write a will, remember you must have at least 2. So anyone can be a witness except the beneficiary or the beneficiary's spouse. So bear in mind, it's very important. So otherwise, whatever gift that given to this particular beneficiary will be void. He or she will not be able to get the gift. So long as he's 18 years old and above and sound mind, so he can be a witness. So witness also play a very important part, later part, when we apply for grant probate, because we got to prepare, normally solicitor will prepare affidavit for the witness to sign. Why? Because this particular witness got to confirm this is a true signatory in the will, is a true signatory of the deceased person. So a witness is a key person also in application for grant probate. So what's the benefit of having a will? So at least you can appoint someone that you trusted to be the executor. You are able to distribute your asset according to your preference, and you are able to appoint a guardian for your minor immediately, and you are able to manage it and distribute your estate once you pass away in a very quick manner. And most important thing is save money so you don't have to spend a lot of money or incur unnecessary expenses. So next, when we talk about save money, how is an estate going to help you to save money? So I believe that many of you might have few properties, you want to transfer the property to your children during your lifetimes. So normally there are two ways of doing it. The first way is normally we solicitors will advise you to do it by way of love and affection. If the property is free from encumbrances, means there's no outstanding sum due to any banks. So it's free already. So you fully paid the loans. So you want to transfer to your children. So many of you might think that the stamp duty is free. Yeah, sorry, no such thing. The governments they still charge stamp duty despite that it's a transfer of property from a parents to a children. But the government is not so cruel. They give you 50% discount. So imagine if you have a property who is worth 1 million, okay, 1 million. So the estimated stamp duty will be approximate 24,000 and the government give you 50% discount. So the stamp duty that you got to pay is about 12,000. So assuming you have a very good legal lawyer friends, so you give you a special legal fees, they charge you only 8,000. So you still got to pay like 20,000 per unit, ladies and gentlemen. So 1 unit, 20,000. So this is this is only my estimation. So normally when my clients come to us, they say that they want to transfer the property to their children. So normally the first question we ask, how much is the market value? Why we ask? Because we have to do a calculations of the stamp duty. Why? Because many of the clients, they don't really expect or budget this legal cost when they do the transfer. So when you do a calculation, we give them a quotation, they get a heart attack. So we rather they get a heart attack at the initial state, but rather later state, halfway, when we submit for education to land office, to LHDN, we get the notice, we give the client, then you get heart attack at that time when we are halfway doing the work. So at least for budgeting purpose. So that's first way of doing things. Second way is you can transfer the property through estate. Eventually, your children is still going to get it. It's just a different way. So one is transferred during your lifetime. Another one is transferred during when you're not around. So if you are transferring the property to your children through estate method, so first thing first, when you're not around, so of course you have to, the executor have to apply for grant probate, which is about 5,000. This is what we estimation. They may be more or less, different firm might charge differently. So estimated for transfer of property, let's say 5,000 per unit. So stamp duty is very nominal, 10 ringgit, ladies and gentlemen. So the total legal cost is about 10,000. So just now, if you transfer property based on love and affections, if you have 3 properties with worth 1 million, so your total legal cost will be 20,000 times 3, so it will be 60,000. But if you are transferring a property through an estate, so you only apply the grant probate once, ladies and gentlemen. So but you only pay like the transfer of property part times 3. If you have 3 properties, then you times 3. So 5,000 times 3 will be 15,000, plus another 5,000 will be about 20,000. So you can see, you can imagine how much you save for the stamp duty. Okay, so this is a comparison for normally I'll do that for my clients to let them make their own judgment. So if you want to do transfer by way of love and affection, then you have to prepare 20,000. This is estimated. So if you want to transfer by way of estate matter, 10,000. That's the legal cost. So majority, when I do a comparison for them, they will do it by way of estate matter because it saves a lot of money. But there are some clients also, they have their own particular reasons. They want to still proceed and go ahead with the love and affection. They don't mind paying the stamp. Of course, to us, we don't mind also because we charge legal fees. So we only take instructions. We already done our job. We analyze the things for them to make sure that they are aware what they are going to. They are willing to pay. Then we proceed, no problems. We only take instruction. Eventually, we are still charging our fees, regardless how they want to do it. Okay, so this is the one of the ways to save money. So next, we are going to save a lot of family dispute. How? Let me share with you. These are typical family issues where many of the couples they will face. Many Malaysians husbands, they love the wife so much. And normally when they purchase a property, they like to put the wife name. So when they put the wife name, some of them that but I don't know why they have this thinking. For some reasons, they thought that when they pass away, the share will be automatically transferred to the wife, which is we don't get the reason. Legally, no such thing. You still have to do a will, go through the graph probate, the estate mechanism to transfer the husband's share to the wife. So imagine when you purchase a property, joint name, unless you specific, otherwise you'll be 50-50. You'll be deemed at 50-50. Each of you own 50%, 50%. So imagine if the husband die intestate. So if the husband die intestate, this 50% will have to be distributed according to the Distribution Act. Remember, just now I mentioned to you the Distribution Act. So 1/4 will go to the wife, of course, 50% already owned. So just add in another 25%, which is not 25, 12.5. So children will get half, and 1/4, 25% will go to the parents. So this means what? This means if the parents one day when they pass away, intestate also, so the parent share will be distributed to the uncle, aunties. Okay, so one house, you have all the uncle, aunties will come into pictures unless they renounce their right. Of course, if they are in good terms, they renounce their right. And if it's a small estate, of course, they renounce their right. But what if it's a very, very big estate? Imagine the husband's estate is 10 million. So 25% of 10 million is 2.5 million. For those that not very high income, 2.5 million is a jackpot for them. So when the husband passed away, the first thing first, the siblings gonna hide the parents. Why? They don't allow the wife to go and see the parents because they don't want the parents to renounce it, right? So eventually what will happen? The wife say, please transfer. Then the siblings might say, never mind, you pay us because this is your share entitled by the parents. So please pay us if you want to get back your share. Pity the husband and wife work so hard, 30, 40 years. Eventually, they have to take up their own savings to buy back whatever is supposed to belongs to them. Very funny, right? But this is the law. And don't laugh, seriously. It happens to one of my clients, Filthy Rich. And this is exactly what happened in town. So please, to avoid all these things, please go and do a will. With a will, you can settle all these unnecessary family issues. Otherwise, you're going to have a family dispute. So some of you might think, sure or not, normally me and my siblings are very good, they're very nice one, they won't do this to me. When it comes to money, anything is possible. We have seen siblings fight each other just to get something because of money. So money is the evil of everything. So please, now is the COVID time. Many things will happen, and I have clients pass away in 10 days time. They want to do a will, but unfortunately, things come too fast. So please, to save all these things, please go and do a will. If you spend a few $100, you can save all these problems. Okay, this is this is a newspaper cutting from Mr. Chinese. It's written in Chinese. So it happens. It came out on newspaper, and a few days ago I see another one. So if for those of you can read Chinese, then just have a look at it. Okay. So by doing a will, you can actually so who is supposed to do a will? So person who set up families, normally we advise them to do a will. So when you start owning a property, please do a will. Or your will is more than 5 years. So many of you might think that I have done my will many years ago, 10 years ago, 20 years ago. So your will is totally outdated. Property that you own earlier already sold, but you have purchased a new property, you never include the will. So when you pass away, so who you expect to know? So I don't think your children will know. So better go and update your will or rewrite. Normally we use the word rewrite your wills every 3 to 5 years. So or if there's any special circumstances that we change your thought, like examples, suddenly your beneficiary passed away, died, or your executor died. So please go and rewrite your will to avoid all these unnecessary complicated issue. So, or you have remarried lah. So some people they divorce and then you make a will, then you remarried. So your earlier will be revoked lah. So please go and do a will. Okay. So many of you, some people they might think when I die, nothing happened. I left. I just leave it to my family to sort it out. But many of you might not think. Actually, the family members they have a lot of pressures to deal with your estate. So first thing first is the funeral expenses. For Chinese funeral expenses, it's quite expensive. So easily it will cost you 20,000-30,000. So if you have to apply for a grant probate, legal costs will incur. And not to forget, there's outstanding income tax or debts that to be paid. So housing loan, some of you, they might think that, I have a lot of houses, 4 or 5 houses. So I leave a wealth for my family, they are going to have a good life. Ladies and gentlemen, if the properties is fully settled, that we call it asset. But if the property is there's still outstanding in the banks, we call it liabilities. So if you are not around, your family members still have to continue paying the installment, serving the installment until the full settlement of the installment. So if you purchase MRTA, okay, good, at least you get something to cover your loan. But I know many Chinese, they don't like all these things. When they see MRTA, 20,000-30,000. Never mind, I shorten the period to 5 years or 10 years, just a minimum. So what happened? If you die, examples, if you die within this period, initially I thought the same is the bank's going to fully settle my loan. But in fact, it's not. Please go ahead and seek for your insurance agents or whoever financial consultant to relook in your MRTA. Some of you, if you don't have MRTA, please go and get insurance policy. So some of you, those who are in business, they keep working hard on the sales, growing the business without knowing, especially sole proprietor, without knowing that one day when they pass on, the creditors go after the family members. So they can go after the estate. Technically speaking, it's not the family, but it's the estate. To sue the estate executor or the administrator for all the outstanding sum. And last, not to forget, your wife or your children need to eat. There's household expenses incurred. So all these things, many people fail to notice all these things. I also personally, I didn't get to know all these things until there's one case that really prompted me, where the client is filthy rich, but liabilities is double of the asset. So the family member have problems in when it comes to managing the estate. So you need cash flow, everyone, ladies and gentlemen, you need cash flow to manage your estate. So the best thing, I'm not the insurance agent, the best thing to do all this, to solve all these problems is actually you buy an insurance policy. So imagine if you have 1 million insurance policy, your wife have this cash flow to play around with all these costs, then you make your family members' life easier. But if you left nothing and you only have like 100 or 200,000 cash in hand and you have to cover all these things, I think that's entirely not enough for your whatever the executor to manage the estate. So managing an estate is something like managing a company. You need cash flow. So a lot of people they fail to realize this, and eventually the family members is the one that's going to suffer all these things. Okay. So traditionally, normally people will go to lawyer, will writer to write their wills. So in this current advanced technology, modern world, we have it online will writing platform. Now we call it Easy Will. So you can, for those of you who are keen to write will, you can actually log in to Easy Will's website, scan all your details, all the information there. Then you can actually generate to print out the wills and to sign. Okay, so I don't want to take so much of your time. I will pass it to my learned friend, Jun Wei, to continue.
Right. Good evening, everyone. Aloha, maybe I'll use my slide.
Sure.
Okay.
You share a slide.
Right. Thank you for your warm response tonight. We will answer your question later, after this sharing. So EasyView, let me introduce what is EasyView. We are actually an online view writing platform to do a view for everyone. So here are the simple steps. So when you come to our website, easyview.com, you will see this layout. So when you click, choose the package, then these are the package available. So how do we try to be innovative enough to in the market is our view is very simple. But of course, if many of you are coming to our talk tonight from your friends' invitation, do go to them because they are well trained. They can give you a very good advice on them. So if you are over the Facebook, you log in, then you will see the fill in the blank that stated me yourself. After you fill in the blank, then these are the things to fulfill. Again, if you do not know how to use them, please go to our advisors. They're very happy to help you. After you key in all the informations, yes, I believe many, if you are really new to the industry, I believe you don't know. So again, please go to the advisors. And after you key in all the information, check out, we will ship the view in hard copy, we will send you the view. So of course, there are also some custody service available. Why custody service? It's because people do not want to keep the view at home so that their children see the view, then the family dispute start. So if we want to avoid this, we also have custody service. So to let the view keep with us. And of course, there will be no obligation, we must execute the view. It's an optional for you. But of course, we tend to provide a one-stop solution. Upon demise, you can choose us, we execute the view for you, or you can choose your lawyer friend. All right. So when you draft the view, these are the summary. You make sure all the information are correct. Your name, IC, details, everything is correct. Then you print out. You receive the copy in this look. You receive the copy in this manner. Then you both document you also have to sign. You must sign both of them. Like Lawyer House say, get two witnesses to make sure they will sign. They witness your signature. Then it become a valid view. So last and not least, the announcement tonight is remember to hit like on our Facebook. We have many updates over there. So you will see us from time to time, we will have more and more activity and talk sharing. Okay.